have a formulation on what you're going to have?
Yes, my lords. And
let's have a look at it.
We've submitted the note, my lords. I think it's page 4 to 5 of your compilation, volume 5. Page 4 to 5, volume 5.
Okay.
It's a 2-page note. My lords have it?
Yes.
My Lord Justice Surya.
Yes. Peaceful.
Yes. My lords, yesterday, my Lord the Chief Justice had posed a question to Mr. Dwivedi that can you look to the statement of a drafter, a member of the Constituent Assembly, and accord it as being enforceable on the will of the people. And it was a very important question. Volume 5, which only has the 1-pager or 2 pages that your lordship had asked for yesterday. So it should be 14, 20 pages between all of us, my lords. Not just me, my Lord Justice Khanna, between all of us. I saw that look of shock and horror on Justice Khanna's face.
Yes.
Be my effort neither to shock nor horrify, my lords. So this was the question posed by my Lord the Chief Justice yesterday. And it's a particularly important question because one, and I'll just formulate the proposition, because one, in this case, you have not one but 2 constituent bodies. So in many ways, it is unique to India's constitutional founding because it is the only state with its own distinctive constituent assembly. 2, it forces upon us this seminal constitutional question. Can the Constitution of India be altered in ways opposed to her founder's constitutional intention? And I'm not saying a drafter's opinion. I'm not saying a debate within the Constituent Assembly. I am saying, can it be altered in ways opposed to her founder's constitutional intention? When we think of this country's founding at a time of partition, from 46 to 49, our Constituent Assembly is drafting our constitution. At the same time, we know what is happening in Jammu and Kashmir. Ms. Ramakrishnan allude to that. The country's first Prime Minister, giving his speech in Hindi, said, "We are a nation whose land is strewn with blood. Khoon se ranga hua hai ye zameen." That is our constitutional founding. So my first proposition is this. There are certain seminal founding moments for any constitution, but more specifically Indian constitutionalism. Why are those seminal founding moments important, crucial, significant while interpreting the constitutions as your lordships will? It is because my lords have walked the path of transformative and expansive constitutional interpretation. And your jurisprudential moorings, with great respect, derive their legitimacy, their integrity, and their intellectual rigor from these founding moments, from our drafters' constitutional intention. If my lords had chosen, since the 1970s, a different path of minimalist interpretation, of limited review, then we would not have to worry about constitutional founding moments. But your lordships have embarked on this methodology of expansive and transformative constitutionalism. And thank heavens for that, because that goes back to the needs of our difficult founding. The creation of this country, 2 constituent assemblies, and also the unique brand of federalism that was envisaged by our founders for the state of Jammu and Kashmir integrated with the Union of India. And it's not just Article 1 and Article 370, which is part of that constitutional intention. It is much more than that. It is the specific provisions, and I'll take you to them very briefly. My lords have read it. I'll just refer to them. It is the specific provisions of the Constitution of Jammu and Kashmir, sections 4 and 5. It is the specific provisions of territorial integrity of the state of Jammu and Kashmir that our founders promised and the Jammu and Kashmir Constitution recognized in its constitutional text. Such territorial integrity was not promised to any other state. This is all part of the founding constitutional intention. Now, in the 1960s, on an aside, my lord, when Thurgood Marshall was asked, why is it so important to have Brown versus Board desegregate America? He responded saying that it is not about their humanity. It is about our humanity. So today I present to my lords a different version of that. It is not simply about that constituent assembly. It is about the promises of our constitution assembly. It is about that legacy of interpretation that my lords started 4 decades ago. That is what this founding movement is about. That is what this model of federalism is about. That is what the intricacies of this model of federalism that embraced this version of what Ms. Ramakrishnan called shared sovereignty. That is part of India's federalist structure. Now, please see, my lords. May I take my lords to section 4 of the Constitution of Jammu and Kashmir, 1957. And the second proposition is this, and it's in the note. The abrogation of Article 370 has vitiated the unique internal sovereignty guaranteed by both constituent assemblies of Jammu and Kashmir and India. And this is in the middle of the note, my lords. So part 2 of the Constitution of Jammu and Kashmir categorically retains internal sovereignty with the state, along with residuary powers to the state government. This is unique to Jammu and Kashmir and distinct from the rest of India, where residuary powers under Article 248 is vested with the Union Parliament. And to this, my lords have sections 4 and 5, but 4 simply says this. It provides that the territory as under 15th August 1947, under the sovereignty of the ruler, that territory is comprised of the territorial integrity of the state. And that territorial integrity of the state is guaranteed to be protected. And section 5 simply says this. It provides that the legislative assembly of the state and all executive and legislative powers, so the legislative assembly of the state is vested with the residuary powers. Now, this brand of the vesting of the residuary powers, the legislative residuary powers with the state assembly, is unique to this state. So whether we want to display that in a conventional setting, a conventional telling that only external sovereignty has been surrendered by the state, in terms of Article 371, and that's a sub-proposition, and internal sovereignty is retained by the state, or whether we want to say that this is shared sovereignty between the state and the union, between the two constituent assemblies. Either which way, and my lords have heard arguments speaking to both those ideas, but either which way, this brand of sovereignty is unique to the state of Jammu and Kashmir, and it is especially important in appreciating the unique federalism that is ascribed to the state in the federalism that speaks to India. My lords, on this note, I won't take you to the speeches, but on this note, we've just made 2-3 references, my lords. Speech of Kotwal Chunnilal during the Constituent Assembly debates of Jammu and Kashmir. And your lordship will just mark that. And that is in the volume compilations. I'll just read a line from that. And he makes only 2 points, that the territories as on 15th August 1947, which were under the sovereignty of the ruler of the state, that is what the state will comprise. And within that, the state will have a legislative assembly and a legislative council. So dual houses and territory ascribed and guaranteed and promised. This is part of the founding. And all of that is marked, my lords, so I won't trouble my lords with it. Now the 4th proposition, my lords. The abrogation of Article 370 and the subsequent Jammu and Kashmir Reorganization Act 2019 by abolishing the bicameral legislature of the state has further violated the unique legislative autonomy secured by the state of Jammu and Kashmir. And this is just on top of page 2, my lords. Now for this, my lords, I'll just take your lordships to sections 46, 47, and 50 of Constitution of the state of Jammu and Kashmir. And my lords, that's in volume 2.
We have it here actually in your note itself. It's the article,
Yes.
section 46.
It's in volume 2, my lords, of the documents.
46 is at
Section
page 5.
46, my lords, pertains to the legislature for the state. There shall be legislatures for the state.
The bicameral legislature,
Yes.
both the legislative
Yes,
assembly
bicameral.
as well as the council.
Yes,
It is extracted in your
At
page
page
2 note,
5.
as the Chief Justice said.
yes, my lords. But my lords, what is important and interesting about this legislative model is that section 47 and section 50 provide for the composition of the legislative assemblies, the assembly and the council. Now, the reason why I'm belaboring this is because the composition speaks to a unique, my Lord Justice Suryakant has that.
Yes.
The composition speaks to a unique regional model of governance. And that unique regional model of governance was only ascribed to the state of Jammu and Kashmir. So 46, 47, and 50. 47 provides for the composition of the Legislative Assembly, and 50 provides for the composition of the Legislative Council.
Essentially, para 7 says.
Yes, Manoj. Yes, Manoj. Now, section 50 of the Constitution of Jammu and Kashmir has unique requirements of this composition. And this shows a thoughtful regional understanding of the state. The Legislative Council is intended not only to have members from districts, but municipal councils, town area committees, panchayats, so on and so forth. Now, this is a very different understanding from Article 171 of the Constitution of India, which provides for legislative councils of a different kind. I just read, my lords, Article 171. Well, Article 171 speaks to the composition of legislative councils. Total number of members, my lords, of each council shall not exceed. Now, subclauses 3 and 4. These are only specialist qualifications. The idea of 171 is not to provide for representation by region, but only to have specialists or memberships of members from specialist institutions.
9A of the Constitution.
Self-governance now in the Constitution has come in a different fashion. It was not prevalent then. So possibly the thought process at that time while creating the bicameral houses was to provide such representations from the ground root level. But the Indian Constitution has also changed over by inclusion of that.
My lords, the reason why I'm showing these distinctions, and my lord is very correct, but the reason why I'm showing this is that there was a method, an intention on how to keep, one, how to recognize the state, two, how to bring the diversity within the state together.
Get a representative character from a base level, sir.
Yes, and diversity of regional representation. The only legislative council which had reservation on religious grounds, Sikhs, had seats. Very unique. So there was an understanding of the people who knew the area best, that there would be a certain regional representation to hold together Jammu, Kashmir, and Ladakh. There is no other legislative council which is thinking through regions, which is thinking through minority representation in this form. So when you take that area and divide it up and chop it up into 2 union territories, you take away all representation from Ladakh.
You got the point. Thank you. Anything else, Dr. Guruswamy?
Yes, my lords, just two brief points. So, my lords, following the abrogation of 370 then and subsequent state reorganization, the Legislative Assembly, 111 members, and the Legislative Council, 36 members, were dissolved. And then you had the state conversion into 2 union territories. Now, of course, Article 169 of the Constitution of India provides for a mechanism of the abolition of legislative councils. I'm saying this, my lords, because it is not as if only 370 has been miraculously removed and ejected in ways violative of constitutional intent. It is that everything that has happened has been contra the Constitution of India, including, for instance, the dissolution of this Legislative Council, which was envisaged by our framers. The legislative councils are meant to be dissolved in a certain manner, but certainly not in this fashion. And that constitutional intention of a recognition of identity, of a recognition of representative democracy, of a recognition of unique federalism extends to all of this. So you are not just running roughshod over 370, you are running roughshod over the small, how you dissolve a legislative council, and the big, how you don't hold elections for the last 4 years.
What is the next point? But the second point?
Yes, my lords. Now, my lords, a small point is that prior to the impugned actions, Ladakh had 4 MLAs and 2 MLCs. It also
Just permit.
my lords.
You said Ladakh had 4 MLAs
Ladakh had 4 MLAs, my lords,
and
2 MLCs. 4 MLAs after the delimitation in 1995 and 2 MLCs pursuant to Section 50, my lords, of the Constitution of Jammu and Kashmir. Also, my lords, it used
representation
Yes.
goes away. I
And
mean, the legislature itself ceases to exist.
Yes, my lords. And my lords, also the Ladakh Autonomous Hills Development Council Act 1995 provided for this Hills Development Council, which provided for decentralized autonomous bodies for governance.
And that has been rendered null.
Yes, my lords. Null and void.
All right, thank you.
This is also. Now, my lords, just two other short
Yeah,
points, and
yeah.
I'll make it very brief. One, my lords, so I should tell my lords, I appear in two matters, so that my lords has that. Writ petition, my lords, 1048 of 2019.
Sheet का है वो.
Writ petition 1048 of 2019.
And you had it only that you are for as an intervener,
No,
Awami
my lords,
National
I
Congress.
appear in two matters. This is writ petition 1048 of 2019
And
intervention number 138432 of
Yes, that we have.
2023.
138.
138432, my lords. 2023, that's the Awami National Conference.
maybe the nodal council will have to just update our sheet, because
Yes, ma'am.
just maybe you can update the sheet anyway, anytime today in the afternoon or evening. Just give it to the court master,
Now,
because we.
writ petition is Shakir Shabir and the IA is the Awami
Oh.
National Conference. Now, the reason why I'm mentioning this also, my lords, and I'm cognizant, my lords,
Yes.
of the large clock at the back. My lords, we're tuned to your lordship looking to it. But my lords, it's this, that in the writ petition 1048 of 2019, there is also a separate intervention.
All right.
And that IA actually speaks to delimitation. And that is
Yesterday
I-
only we said that that issue stands concluded by the judgment of my Lord Justice.
Yes. Now, my lords, respectfully, the judgment of your lordships, Justice O categorically states that the abrogation, the State Reorganization Act is not being challenged in this judgment. My Lord Justice Call knows that. My Lord Justice Call knows that. Therefore, my lords, and Justice Oak in that case also specifically says that counsel should have raised it initially, or it should have been pled in the petition. He says that in his judgment. And because it is not pleaded, we are not assessing delimitation in context of that. That is abrogation and reorganization.
We assessed the limitation, but we did not go into any other issue.
Yes.
Those
No,
issues
my
are
lords,
not
may I just show you those?
How does unless there's a reference made or something made, how does that issue crop up here?
My lords, because your lordships are seized of everything that falls out of abrogation and reorganization, including delimitation.
But that part is concluded by the judgment. I mean, there's no reference to this bench on that issue.
But my lordships, at that time, justices call.
Somebody should have come there then. We have heard other people there, whoever wanted to on delimitation. If this person was so keen, and that also, he has moved an application of intervention in this 1028 of 2019. He is not a petitioner, according to you. It's through
No, my lords, the same petitioner. This writ petitioner,
he filed a separate application.
yes, in his own writ petition, has filed an additional application vis-a-vis delimitation because it occurs subsequently.
This can't be in the form of an application in a
In
petition.
a matter of this nature, it becomes too complex to get into this. You have to confine to what is there before us.
My lords, I follow and I bow down, but I will only say this, my lords, and your lordships may just, I will only say this, that at present, not only have the state been turned into two union territories, the delimitation exercise, which breaks down individual constituencies, which goes against that regional autonomous model of federalism promised in the constitution of Jammu and Kashmir, is now rendered not.
That point you have made.
And therefore, I went through all those points to show that this is a unique model.
That's fine.
Now, if
That
you,
point you have made, though.
yes, now if you've chopped up those constituencies, and that is what has happened, my lords, it's the chopping up of constituencies.
That will happen. Delimitation exercise always envisages inherently a change of constituencies.
My lords,
Otherwise, why have a delimitation?
But my lords, the respectful submission is that the delimitation exercise must either conform to the constitution's requirements.
Okay, that the adjudication
Yeah,
will not
or, and given that your lordships are seized of abrogation and the Reorganization Act.
That's fine. That's
That's
why it
all
was
right.
not
That point
touched.
you have made, that, this eats into the regional autonomous model of federalism. That point you have taken.
Wait, wait.
Thank you, Dr.
So,
Guruswamy.
my lords, just that, and then I'll end with this,
Now,
my lords.
Manish Tiwari will call upon. Yes.
My lords, I'll just end with this one
It's almost
point.
30 minutes now.
30 minutes, my lords, it can't be. It's felt like 2 minutes. It's the best 2 minutes.
What is before us?
All right. Yes.
No.
Last was the point. Yes.
I'll just end with this, that part of this is that we made promises. We, the people, through our drafters, made promises. It is surely an axiom of decency, constitutional integrity to keep our promises.
Thank you, Dr. Guruswamy.